This lecture focuses on contract law, including parts of the contract, contract types, components of a contract, as well as contract provisions. There are three parts to a contract, starting with the offer. The offer discusses the terms of the contract, like who is involved, the length of time, anything that will cause the contract to be terminated, as well as what people are offering. So they identify what will be included, like money in exchange for purchasing equipment or a service. And the other party can make a counter offer if you don't like the terms that are presented to you. The next part to a contract is acceptance. This is where you agree to the offer. You can do this by saying verbally, yes, I agree to this offer, by writing it down. But basically, you need to communicate to the other party that you are agreeing to what they have presented to you. The third part to a contract is what is called consideration. This is the value or benefit given by both parties. So, for example, A'ja Wilson is a WNBA player. She signed a deal with Ruffles Chips. Ruffles pays A'ja to use her likeness on the bag and in ads to help sell their chips. So the consideration for both sides is Ruffles gets to use her likeness and she appears in ads, and then Ruffles pays A'ja Wilson to promote their product. So a couple things to keep in mind is that consideration cannot be for past performance, so you can't pay something for something that's already been done over and done with, and it cannot be for an illegal act or service. Here are a few other examples of consideration in contracts. The first is money for a jersey logo sponsorship. Tria Orthopedics and the Minnesota Wild have a contract in which Tria pays to be able to be the only jersey sponsor on the front. Another is money for promise to provide the use of an arena. So oftentimes professional sports teams don't outright own their arenas. They lease them from the city or the state, so they pay money to use that arena or stadium. And then the third one is an act or promise not to act. So it's basically like deferring something in a contract to later on. There are two other factors that make an enforceable contract. One is that the contract covers something legal. It can't be enforced if the product or service that is being bought or used is illegal. The next is the person signing the contract needs to have capacity to understand what's going on. So they need to be over 18, mentally competent, and not under the influence. If the person is under 18 or lacks the competence to understand what the contract states, then normally a parent or guardian will sign for them. The next couple of slides run through some common types of contracts that you've probably seen or signed yourself. The first is an employment contract or a job contract. The next is a sponsorship or marketing contract. So, for example, this gymnast on the right has a contract with Accelerator Drinks in which they pay her to market their product. The third one is a media rights contract. So, for example, NBC has the media rights to the Olympics, so they pay the IOC, the International Olympic Committee, for the rights to broadcast the game in the United States. Here are some additional common types of contracts. The first are games and events contracts. So oftentimes schools in the Power 5 conference of Division I and men's football and men's basketball will have games that are called guarantee games where they pay other smaller Division I schools to come in and play them. So it provides money for that other small school's athletic department and allows the big-time athletic department to get some reps in for their subs. The next are facility leases. So, for example, the dome we have on campus is often leased by members of the community who can come in and use it for their practices and games and so on. Waivers and releases are a very common type of contract, helps minimize the risk of the organization. And then finally, equipment purchase or rental. So anytime, we see at events like tents are out there, big tents that they have hospitality under, sometimes those are rented from other organizations, and there are contracts that go along with that. There are several contract provisions to keep in mind to make sure a contract is clear. The first is the party designations. These are the individuals and organizations who are named in the contract that are expected to carry out the contract. Terms refers to the length of time the start date and the end point for the contract. Warranties and representations refers to the idea that there are some things that need to be true for the duration of the contract, like one company shouldn't promise that they're not going to go bankrupt if that's going to happen. The next are obligations and duties, and these are basically the consideration part of the contract, what both parties will do or give as a result of the agreement. And finally, the termination clause outlines what would lead to the end of the contract between the organizations or individuals. Here are a couple of contract clauses to keep in mind. There's termination for just cause, which allows an employer to fire an employee for misconduct. So in some instances, there's specific language on firing in coaching contracts for breaking NCAA or state or federal laws. The next is termination without cause. So allows the employer to fire an employee without giving a specific reason. Oftentimes in college coach contracts, you get fired because the university wants to win and they weren't winning enough, so they fire without cause. For example, the O'Brien versus Ohio State University case is pretty famous. Ohio State fired O'Brien because he loaned money to a player and didn't report it, which violated NCAA rules. They fired him for cause. He sued. The court ruled that firing O'Brien was excessive because following NCAA rules was only a small part of his obligations and duties, so they could have dealt with this another way and not just outright fired him. Some other contract clauses include a rollover clause, which keeps the contract going from 1 year to the next, so you're not signing a new one every year. The next is a reassignment clause. So instead of firing a person, employers can move the employee to a different job within the organization. So, for example, a coach gets moved from a coaching position into a fundraising position. And then a force majeure clause we saw during COVID, which is a clause that enables the party to get out of a contractual obligation for a catastrophic or unforeseeable event like COVID-19. A lot to keep in mind is the parole evidence rule. And that says once a contract is written and complete, a person can't come in and say something was supposed to be included after the fact. So you can't try to keep adding stuff on, pretending that you had talked about it before. This law states that what's in the contract is what's in the contract. Another one to keep in mind is the statute of frauds, which states that specific types of contracts always need to be in writing in order to be enforceable. Those are things that include the sale, mortgage, or lease of land, contracts that cannot be performed within a year, and those contracts that have a value of more than $500 all should be in writing. Another contract law statute to keep in mind is promissory estoppel. This is a legal doctrine that stops a person from going back or withdrawing on a promise to create a contract when the contract doesn't exist yet. So there's an assumption that the contract is going to be created, so a person starts working and starts spending some money perhaps, and then the other person backs out, which creates the lawsuit. So the elements of this are that there's an existing legal relationship. There's a promise, as in they're about to create a contract. One party starts to work on the things that are in the contract before the contract is actually finalized, and the other person backs out, and the one party incurs some sort of financial loss, which results in an injustice. And this is the way for that plaintiff to recover some of the damages. A couple types of contract breaches are material. This is when something is substantially different from what was expected under the terms of the contract to what was actually delivered. So, for example, Odell Beckham sued Nike recently, claiming they depressed the sales of his jersey, so he would get a smaller royalty payment or payment from them because he gets a percentage of of the revenue that's sold from when his jersey is. So he's saying he's owed millions of dollars from that contract, which is pretty substantial. A minor contract breach may be, he's not claiming this, but it could be like they were supposed to send him his cleats at specific dates in the year. They sent them 3 months later. You know, it's sort of a minor issue, but it still could be impactful on his performance on the field. This slide discusses some legal contract remedies when the contract is breached. The first is restitution. That's basically giving the plaintiff money or property that they were owed through the contract. The next is rescission. This terminates the duties of both parties under the contract, so then the contract is done. No one should expect anything from the other party. Reformation allows the courts to really change what's in the contract to help fix it, or fix it for both of the parties to make it a little bit better. Specific performance actually forces the defendant to perform what was laid out in the contract. This chapter focused on contract law, which reviewed 3 parts of a contract: offer, acceptance, and consideration. Along with that, it reviewed legality and capacity, the things that make contracts enforceable. They need to be of legal services or products, and the person has to have the capacity to understand what is going on in the contract. It also reviewed various contract components like party designations, terms, obligations, and duties, as well as things like termination for cause, termination without cause, and then finally touched on some contract breaches and ways to remedy those breaches.